great Sergeant at Arms, Terry McCraw.
If we get some new ones.
Yeah, Nina Lage, Dean Marshburn, and Ray Cook. Thank you very much. We do have a number of pages with us. I'm going to have them introduce themselves if they will come up to the microphone and just tell us your name and your county and who sponsored you.
My name is Spencer Wright. I'm from Wake County, and Julia Howard is my sponsor.
My name is Cameron Lyerly. I'm from Mecklenburg County, and Representative Laura Budd is my sponsor.
Good morning, everyone. My name is Anaya Campbell. I'm from Chapel Hill in Orange County, and Representative Buansi is my sponsor.
Hi, everyone. My name is Zoe Zhang. I'm also from Chapel Hill, and Representative Buansi is also my sponsor.
Hello, my name is Griffin Fitzgerald. I'm from Gaston County, and Representative Loftus is my sponsor.
Awesome. Well, very good. Thank you very much for being here and all the work that you're going to do, and hopefully you're going to learn a bit this week. We have a big agenda today. We started off slow, and we've added to it all day, so we're going to go ahead and get started. The first bill that we're going to hear is House Bill 693, the Interstate Massage Compact. Representative Warren and Riddell.
Thank you, Mr. Chair. House Bill 693 offers North Carolina an opportunity to join Arkansas, Montana, Nevada, Ohio, and Virginia as the founding charter members of an Interstate Compact Massage Commission. This commission would serve as the instrumentality for all the member states and create a multi-state license which give flexibility for other licensed massage therapists to come into North Carolina and vice versa. You can kind of think of it as reciprocity on steroids. This bill has the support of the Federation of State Massage Therapy Boards, the Associated Bodywork and Massage Professionals, and the United States Department of Defense, and military families throughout North Carolina. I'd appreciate your support for a favorable vote and a referral to Finance. I stand for any questions.
Any questions from the committee? Representative Campbell?
Just motion at the appropriate time, Mr. Chairman.
I know we've heard a number of compact bills. Okay. We do have a couple members of the public who wish to speak on this bill, and because of time constraints, we'll give you 1 minute to speak, and we'll just get Grant Minix, and then Chance Quick, Samantha Sliney, Alan Shader, and then Palmer Suggs in that order. So, Grant Minix.
Mr. Chairman, members of the committee, thank you all for the opportunity to speak before you today on the Interstate Massage Compact. My name is Grant Minix. I'm a policy analyst at the Council of State Governments. We at the Council of State Governments developed the Interstate Massage Compact, as well as all of the other professional licensure compacts that have been before you here, all 18 of them, predominantly in healthcare professions, through a cooperative agreement with the United States Department of Defense and the Federation of State Massage Therapy Boards. The Interstate Massage Compact works similarly to the Nurse Licensure Compact, which sets up a multi-state license for individuals to obtain, which works kind of akin to your driver's license, allowing you to have one license and practice in multiple states simultaneously. There's a number of benefits to this, obviously to the practitioner, but also to clients of massage therapies. They receive kind of those additional benefits and reciprocity of service between states. Also, the public protection.
Please summarize.
Pardon?
Please summarize. We only have a minute for our speakers, so
okay. Well, I will
fast.
Thank you. And just to wrap it up, the number of public protection aspects with this, happy to touch on those with the shared collaboration between states to ensure public protection between states, and I'll yield to any questions.
Thank you very much. Maybe Dance Quick, come on up, and then Samantha Sliney, get prepared.
Hi, I'm Janae Quick. I am a massage therapist. I live right outside of Charlotte, and when the hurricane came through last fall and decimated the mountain area, and all of those massage therapists wanted to work and could not work when they went home to their families in South Carolina and Tennessee, and they wanted the opportunity to support them families, this bill would have made a difference for that. And now we see it happening in West Virginia, where areas are getting pummeled, and if people can move to a different state temporarily and work, it would make a huge difference in our workforce. Thank you so much. I hope you vote favorably.
Thank you very much. Sorry I butchered your name. Ms. Sliney?
Good morning, Chair Reeder, Lambeth, and White, and honorable committee members. My name is Samantha Sliney. I'm from the Department of Defense State Liaison Office. Our office is established to make connections between the DoD and state leadership within the state. I will defer to any questions that the committee members might have. I'm happy to get into the details of the difference between the Service Member Civil Relief Act, reciprocity, and compacts, and how they differ and how they work together and complement one another. This time I'll yield my time for any questions, and if not, the DoD asks for your favorable vote on House Bill 679.
Thank you very much for coming. Ellen Schechter? And then Palmer Suggs, you're on deck.
Hi, my name is Elon Schachter. Good morning. Thank you for allowing me to speak. I have been in this profession for over 30 years. I've been an instructor for 20. I currently am the program director at South Piedmont Community College, serving Union and Anson County with a large group of students from Mecklenburg. Go Alligators. I have worked with the TAG group, the Technical Assistance Group, to help build this. And I want to say, it is built to help protect the public. We have raised the bar, and that is essential for safety of our public. By raising the bar, we are requiring FBI background checks, fingerprinting, photographs for anybody that wants to be part of this compact. Right now, if you look at a website that I don't recommend looking at called RubMaps, there are 46 illicit massage businesses in Raleigh, 514 in North Carolina. We need this to stop. This should help.
Thank you very much. Mr. Sugg?
Thank you, Mr. Chairman. My name is Palmer Sugg. I'm here as an attorney for the North Carolina Board of Massage and Bodywork Therapy. The board deeply opposes this bill in its current form. The reference to reciprocity on steroids is probably accurate, because steroids are great until you get a hold of the side effects. And that's what the board is worried about in this case. This will provide loopholes to licensure from other states. There are registration, notification, and identification issues that the massage board is required to enforce. And if this bill passes in its current form, the board will be unable to track some of these out-of-state folks. With regard to illicit aspects, I don't think we could agree more that we need to do away with the illicit aspects of the practice of massage. That is what this board was licensed to do in the beginning. And with regard to other compacts and practices, the difference in massage and other forms of practice that have had compacts, massage is 100% hands-on. There's no telehealth massage, and that creates another issue for this board. Thank you.
Thank you very much. Any other questions from the committee? Okay, seeing none, I think Representative Campbell, you have for a motion?
Mr. Chairman, I move for a favorable report and referral to Finance Committee. Thank you.
Everyone has heard the motion. All in favor say aye. Aye. All opposed say no. No. The ayes have it. The ayes do have it, and it will move on.
Thank you, Mr. Chair. Thank you, committee.
The next bill is Senate Bill 77, School Contracted Health Services. All right. Senator, I think we have an amendment. If it's okay with you, we'll take that first. I think Representative Biggs, you're going to offer that.
Thank you, Mr. Chair. This amendment ensures that when a child's individual education program, or IEP, requires nursing services, The parental choice of the nurse may be assigned to that child, provided the nurse meets 4 conditions, such as being employed by a licensed agency, having prior relationship with the child, and coming at no greater cost to the LEA. This amendment supports continuum of care, respects parental input, and maintains existing contract safeguards of cost neutrality for the district. I thank you for your support.
So we have the amendment before us. Would you like to speak on the amendment?
It is a favorable amendment, committee.
Okay. Any questions from the committee? Seeing none, we have the amendment from Representative Biggs. All in favor, say aye. Aye. All opposed, say no. Okay, the ayes have it. The ayes do have it. So we're back to the original bill as amended. Go for it.
Thank you, Chairman, and thank you, esteemed members of the Health and House. And I'm appreciative as a senator to be here to answer any questions. Representative Biggs basically said it all. Just allows for nursing contracted services for a family who may use a nurse at home to be able to use the same nurse at school as long as that nurse is qualified with the school. And I stand for any questions.
Any questions from the committee?
It's more a curiosity question, and thank you for bringing this. Why did this come up now? Why have we not done this in the past? I'm kind of curious.
Thank you, sir. It's my understanding that there are some stakeholders, and they were allowed and went through the contracting services through a local school administration, but was not allowed to perform those services on site. So this is just shoring up the fact that if a provider is available to give care at home, they can also give the same care at school, so that the child has the best needs available, or the best services available.
Any other questions from the committee? Yes, Representative White.
Thank you, Representative Sark. When this nurse goes into the school system, would that be just at a time that the child needed it, or would this person be with the child all day long in school? And if that's one question, and then the second question is, if the answer to that is yes, they will be with the child all day, will they have to work with the local school system to have the qualifications to be in the school every day, just like anyone else that works in the school would have to have qualifications? Thank you.
Mr. Chair.
Yes.
Thank you.
Go ahead.
Well, thank you, Ms. Chairwoman. And really the answer to the first question is it depends on the individual education plan of that student as to how long that they'll need nursing care. And this answer to the second part of your question is yes. That is what this bill is doing, is solidifying that relationship between the home health care nurse, the community, and our church, so that that child can have the same nurse both at home and at school, as long as that company meets the criteria set forth by the school district.
Representative Biggs, recognized for motion.
Yes, sir. I move the Senate bill as amended be rolled into a new committee substitute, and the new committee substitute be given a favorable report, unfavorable to the original bill.
All right. We have a motion in front of us. And all in favor say, did you have, I'm sorry.
Mr. Chair, I think you just missed me.
I'm so sorry.
Thank you, Mr. Chair. I had one question. And the question is in reference to an independent contract up under the school district. Does that have to exist as a third-party contract for them to be able to do the continuity of care?
Senator.
Yes, ma'am, that is my understanding. We do have representatives in the audience, so if I've misspoken at any point, I invite them to say that, but from my understanding, yes, ma'am.
Thank you, Mr. Chair.
And I apologize for missing you. You need to throw something harder next time. Representative Biggs, we have a motion before us as amended. All in favor say aye. Aye. All opposed say no. Okay, the ayes have it. The ayes do have it, and we will move that forward to rules. The next item on our agenda that I've just lost, is going to be House Bill 479, the SCRIPT Act.
Mr. Chair.
Yes, ma'am. I'm sorry.
Inquiry of the chair, please.
Yes, go ahead.
I think everyone knows that we just got this, and I'm getting messages from people who are outside the building that don't even know that we're considering, and I haven't even had a chance to read it. Could this only be for discussion today at least?
I think in the interest of time, we'd like to move this forward at this time. We've heard a PBM bill in this committee before, but we're really running out of time, so I'd like to hear the bill for vote today.
Follow up?
Yes.
I believe our rules require that we see these PCSs the night before.
Yeah, without objections, we would.
Objection.
Okay. Yep, so we have an objection to hearing this PCS. So the rules will be that we'll vote on whether we'll hear the PCS at this time. So I'm looking over my shoulder to make sure I'm correct.
Mr. Chair, just a clarification.
Yes.
I'm not asking that we don't hear it, just ask if we discuss it and perhaps vote on it at another time. Maybe even recess for a while so we can read it. Thank you.
Heard the objections. I think the challenge is we're running out of time with which I think that we can have the debate today and move along. So the chair's ruled that we without objection, so there was an objection. We will take a vote on whether we'll hear the PCS at this time. So all in favor say aye. Opposed? No. In the opinion of the chair, the ayes do have it. The ayes do have it, and we'll go ahead and hear the PCS. All right. So, Senate Bill 479 is in front of us, and we have a PCS. So, Representative Ryan, why don't you hold for just a second? We're going to let staff explain that I think I did everything correctly. So, Jessica.
Thank you, Mr. Chair. Jessica Boney, Legislative Analysis. Just for the committee's purpose, Rule 36.1A, distribution of proposed committee substitutes, says that this requirement may be waived by leave of the standing committee. Thank you, Mr. Chair.
Representative Cervania.
Chair, may I ask Ms. Bodie a question on the rule?
Yes.
According to Rule 36B, doesn't it state that a PCS should be received no later than a day before?
Correct. Yeah. Jessica Boney, Legislative Analysis. Thank you, Representative Cervania. So you're correct that there is the 9 p.m. requirement. Why don't I read all of 36.1A and then...
And B, please.
So I'm looking at 36.1A-B says that, well, let's read the whole thing. So 36.1A, distribution of proposed committee substitutes. A, no proposed committee substitute may be considered by a standing committee unless the proposed committee substitute shall have been distributed electronically no later than 9 p.m. of the preceding calendar day to the members of the committee and to the member who's listed as the first primary sponsor. This requirement may be waived by leave of the standing committee. B, subsection A of this rule does not apply to a proposed committee substitute establishing districts for Congress or state senators or state representatives. Representative Cervania, which rule are you referring to? I might have missed that. Okay. Staff will ask for just a moment to look into that.
You can be reading while
Mr. Chairman, I was also going to say this. Why don't we go ahead and hear the bill, and then if we're still, some are uncomfortable, we could deal with that. But let's at least hear the bill. Yeah.
Just in the interest of time, thank you, Chairman Lambeth. Let's move forward, hear the bill, and if we need to work out some parliamentary procedures, there's uncomfort, then we can come back. So, Representative Ryan.
Thank you, Mr. Chairman and members of the committee. And I just want to say I appreciate your concern, but what I want to do is first off alleviate any fears and let you know that Senator Saari has been fantastic to work with on this bill. I think we have found a healthy compromise in this bill. However, as great as I think it is, I do anticipate that the Senate will probably non-concur on this, and it will go to conference, which is probably what's going to happen. But Senator Sari, and he's welcome to come and speak as well, had some really good points in his bill, some good provisions in there that I have left in there. I have included a lot of House Bill 163 in here as well, and made some compromising points. One of the biggest things that you'll notice that may be new to you on the House side is the addition of Part 2, the Pharmacy Services Administrative Organizations Transparency and Freedom of Contract. So this is another middleman, so to speak. It is something that needs to be tackled. It is not something that we chose to tackle in our bill, but you'll probably remember me saying that needs to be done. It was in Senator Sari's bill, so I have left pretty much all of that in this sort of compromise that we have here. I do feel like it takes both of our bills and takes some of the best parts of them and puts them together. The Senate has been very willing to have conversations, and I think finally has an appetite for this PBM reform. And so I'll stand for any questions that you may have.
Questions from the committee? Representative Campbell.
Just motion at the appropriate time, Mr. Chairman.
Representative Lambeth.
I just want to make a point. You know, Representative Sasser was on this committee as chair. I don't know how many hours that man put on PBM reform, but he put in an enormous amount of time. He was a pharmacist. Guess what? Our representative there is also a pharmacist. They know what they're talking about. This is a potentially a very controversial bill, and there's some that don't like it, but I do think we have to reform and move forward. And I think she's exactly right. This probably will have a conference committee appointed and some issues worked out. And that's, I think, why we probably need to go ahead and vote it so it moves it along to the next process. But we've heard about this PBM reform for a long time because Representative Sasser routinely challenged our health committee to hear the bill and get it moving forward, and it just never could quite get the traction it needed. So I thank both of y'all, both Senate and House, for coming together, trying to figure this out. It needs to be done at some point.
Representative Cervania, did you get all your questions answered?
Yes, Chair. Thank you.
All right, very good.
Thank you to Ms. Bodie, too.
All right. Representative Ball.
Thank you, Mr. Chair. This is very, as you noted, very complicated, and as I asked, it would be helpful to have some chance to not only absorb it individually, but to get some feedback from, for example, I met at length yesterday with an owner of a independent pharmacy who was very encouraged, Representative, about the work that you have been doing, Representative Ryan, on trying to find some sort of a medium, and I just feel like I don't know what's in here, and certainly I believe you that it's better perhaps than it might be otherwise, but I understand about moving it, but if this is going directly to rules, we all know it cannot be amended in rules, so it'll only be able to be amended in on the floor. And if the Senate doesn't concur, as you said, they'll go to a conference. So I frankly just don't know how to vote.
Mr. Chairman, if I could respond to that.
Go ahead.
I want to say that voting on this today and voting yes to move this forward and potentially to send this to conference eventually is not going to cut off any conversation. And I don't want to speak on behalf of Senator Sari, but I think he would probably agree that we are both still very open to hearing from those outside people as we continue on with this. But what we've tried to do is take our two bills and see if we can marry them a little bit and move this forward so that we can continue to have those conversations. There may be a tweak or two that needs to be made here and there. I will not commit to you that it's perfect, but I will commit to you to continue to have conversations like I've been doing throughout this process.
And you'll see in a minute, we had a bill that went to the floor that's coming back to us this morning. So there's still going to be an opportunity if there's significant issues to come back. Representative Cervania?
Comment, question?
Go ahead.
We're not here to say yes or no to this bill. We just want to make sure that we have the proper time to get the proper information. We weren't all 100% with your initial bill, and then we've never seen what Senator Sari's bill looks like in theory. So, yes, this is not enough opposition, but for us to be proper representatives, I think we need to do due diligence and hear from other people and analyze it for ourselves. But if that, and we can't guarantee that there's gonna be conference and maybe it'll go through and nothing changes. I see that there's distractions, so I'm gonna stop there. But we wouldn't be representatives doing our part if we didn't try to do our best at the times that were proposed.
So I guess that what we've been discussing is, would it be beneficial to the committee to get some amount of time to take a short recess to allow you to read through the bill?
There's 20 pages. I don't know if my colleagues, I mean, it could go up to a vote, but 20 pages in analysis, I already sent it to my pharmacy people, and they said, when can I give this back to you? I go, now. So I'm not sure a recess would be a sufficient time.
Okay. Representative Miller.
Thank you, Mr. Chair. Just for a comment, you know, I've been here 5 years now, and I've been hearing about this for 5 years. And Representative Ryan is a subject matter expert, and I trust her judgment. I've heard from pharmacies back home in Brunswick, New Hanover, so I would ask my colleagues to support this bill.
Representative Crawford.
I just have what I think is a simple question, I hope. So can you just help me understand, does the PCS apply to only independent pharmacists, or does it apply to all pharmacies?
Representative Ryan.
All pharmacies.
Okay, thank you.
Seeing no further questions from the committee, I think Representative Campbell, you're recognized for motion.
Mr. Chairman, I make a motion for an unfavorable report for the 5th edition and a favorable report for the PCS with referral to rules.
Motion's in order. All in favor, say aye.
Aye.
All opposed? The ayes have it. The ayes appear to have it. The ayes do have it. It will move on to rules.
Thank you, Mr. Chairman, committee.
I'm gonna.
But now here, Senate Bill 600. As of immediately, all the green lights are handled by a master switch up here, so I have all your lights turned on. I knew Representative Crawford would check it out. She wouldn't believe me. Representative Reeder, you're recognized.
All right. Last week we heard Senate Bill 600, which was.
Excuse me. The PCS is properly before us without objection, so now you may proceed. Thank you.
Thank you very much, Mr. Chairman. So we heard Senate Bill 600 last week. We had a number of provisions that were there, passed unanimous, and we found that one of the bills that we had included had been put in another vehicle on the Senate. We have two changes to the bill before you today. One of them is to remove one of the provisions that dealt with Medicaid personal care services. That is in another vehicle. The only other change since we saw it last week was to redefine the epinephrine injectors. In the current language, it says an auto ejector. There's another manufacturer that has a different way with which to shoot the epinephrine into you. So we've updated that so that we've included all of the epinephrine injectors into that. Those were the only changes to what we passed last week in Senate 600. I'm happy to answer any questions. So this will be the third time we get to vote on these great bills.
Okay. Representative Cunningham, you have a question?
No question, a motion at the appropriate time.
Other questions, Representative Savania, Representative Crawford. I'm not picking on you, I'm just giving you the opportunity to be first. Seeing none, Representative Cunningham, you're recognized for a motion.
Thank you, Mr. Chair. A motion for a favorable report to Senate Bill 600. Look like that's it. It's a PCS, I'm sorry, favorable to the PCS for Senate Bill 600.
And a referral to rules.
I didn't see, yeah, okay, thank you.
Thank you. You've heard the motion for a favorable report for the PCS, unfavorable to the original bill with a referral to rules. All in favor, aye. Aye. All opposed likewise. The motion passes. The bill passes. Representative Reeder, you're back.
All right. The last one on our agenda today is Senate Bill 442. And I think Senator Galey is going to start this one off. And there's no PCS, no amendment, so we're just on the bill. Senator Galey.
I believe Representative Blackwell had an amendment. I don't know if he wanted to say that for the floor. It's fine with me if he wants to offer it now. It's up to you all.
I was only holding off out of total respect for the Senate. If the Senate's good with the amendment, I'm happy to go with it now.
I think it.
We'd have to print it out and distribute if you'd like to take that up. So you'd need to give us a few minutes.
Well, why not? I'll just do it on the floor and save time now, if that's okay.
That'd be fine.
Thank you.
Senator Galey, you're on the original bill.
Thank you, Mr. Chairman. The amendment is wordsmithing. It's doesn't change the substance of the bill. It's friendly, and it's Representative Blackwell's excellent wordsmithing as usual. And it's appreciated. So this bill is very simple. All it says is that if you have a child in a home that is a loving home where the child's needs are being met, there is no abuse, there is no neglect, that child cannot be removed from that home solely because whether it's the child's natural parent or their adoptive parent, solely because the parent does not support or go along with that child having a gender transition. That is the only thing that this bill does. If you have a child who believes who has gender dysphoria, living in a home, and the parents, for religious, whatever reasons, do not support that child transitioning to a different gender, that cannot be the sole basis for that child being removed from the home by the state. This bill does not touch on custody disputes between parents. It also does not, we originally had some language about foster children and foster families. We took that out because of the complexities in those relationships and parental rights, and that they don't lose when the child enters the foster care system. So that's out. And the reason, Mr. Chairman, that this bill is important is in looking around the country, we have seen instances where parents, in fact, have lost custody of their child simply because they didn't agree with the transgender or the transitioning of a child with gender dysphoria. In my opinion, that leads to a chilling effect. Very often, the children become intersected with the state involvement, not because the parent has been abusive or neglectful, but because they've sought medical care for this child. And the child has other psychiatric needs. For example, one child that was in the news had anorexia, and the parents sought treatment for that mental health disorder. During the course of the treatment, it became apparent that the child had gender dysphoria, and then the child was removed from the home, just because the parents didn't agree with the transitioning. So it's not a complicated bill, it's simple. I think it leads to better mental health outcomes in the long run for children because parents will not be chilled or be penalized if they seek out appropriate mental health treatment for their children. They don't have to betray their own religious values in seeking those resources for their children or be concerned.
Thank you. Questions from the committee? Representative Loftus.
Thank you, Mr. Chairman. My question is, we talked about the child being removed also want to cover down on preventing those foster parents from being disqualified simply because they have close-held religious beliefs that may be used against them in disqualifying them as a foster parent. I know currently the DHHS uses the Foster Care Bill of Rights, which talks about the consideration of whether or not that would play a role in impacting whether or not placement would be completed with that foster parent. So my whole focus is to make sure we're not disqualifying potential foster parents, because in Colorado, California, and Washington, that's currently being used as a disqualifier. Just as much as in the law it says race cannot be used as a disqualifier or a qualifying to say where we're placing this child because it needs to be in a safe, loving home. Race doesn't play a part. I don't want those foster parents being disqualified, simply that we're using the guidelines to say we want to measure the impact of that. Thank you, Mr. Chairman.
Comment?
Yes, I would just mention that the bill has the foster parent section taken out of it at this point. So the concerns that Representative Loftus is raising aren't addressed by the bill in its current form.
Representative Crawford.
Thank you, Mr. Chair. Senator Galey, thank you for bringing this bill forward, and I appreciate the fact that this foster care language was taken out. I think that is an improvement to the bill given the complexities that you mentioned. I still do have some concerns about this bill related to the mental health of children, and I just I'm worried that, you know, depending on the situation, that this may make it harder for healthcare providers to follow up and child welfare workers to follow up if a child is being harmed emotionally, which I would argue if their gender identity is not supported in their household, I'm concerned about the emotional harm that could be done to that child.
Comment?
I would just say that the bill says that, you know, there's other acts or omissions prohibited by the subchapter that would constitute abuse or neglect, including abandonment or the creation of injurious environment, that those acts or omissions could still be considered. And so I don't think that, without, you know, respectfully, Representative Crawford's concerns are borne out by the bill itself. And as to emotional harm, I think that when we think about abuse and neglect of children in terms of purely emotional harm, I think that's really a morass, a place that you can get tangled up very quickly. Children get unhappy about a lot of things that their parents do and say. I'm looking at the child welfare practice guidance for LGBTQ+ youth from the North Carolina Department of Health and Human Services. And in its guidance for working with LGBTQ+ children and youth, it tells social workers to consider whether the youth is at risk of maltreatment and rejecting behaviors such as, the last one is pressure to be more masculine or feminine, or being forbidden from dressing or grooming consistent with the youth's gender identity. And I just really question whether or not that is leading us into an area of second-guessing parents who are just trying to do the best that they can with the information and the resources that they have in front of them. I know that I have raised a teenage daughter who was forbidden from dressing in a certain way, and she definitely expressed emotional distress about that from her mother. But sometimes parents have to say things or lay down, have to direct their children in ways that they disagree with. So fundamentally, the most important thing, I think, before this committee is that parents don't have to worry about those decisions and those discussions resulting in the removal of their child from their home by an agent of the state.
Representative Cunningham.
Thank you, Mr. Chair. I just had a few comments. Religious beliefs and cultural norms have been around forever that have been available to parents that have a tendency to send them forward, and the kids start to learn those as well, to adapt. And the Maslow hierarchy of needs is protection, safety, food, and shelter. They have that responsibility. And my thoughts are on this is that when the child is in the care of the parent, if the child is not being harmed, neglected, or abused, then that parent still has the authority to practice their religious beliefs and their cultures within their home with their children presiding there, as long as they are responsible for them until they become an adult, and that is at age 18. So I don't like to get in the weeds on the gender about this and that. The mental health component is going to be there for those children. And we're not the experts, and we're not the ones that's going to be in the room with them dealing with those issues. So I think we need to move forward and let that go ahead and take the place of us digging deep down into who gets to decide who takes the child from the parent based on an issue related to culture or religious beliefs.
Comment?
That's awesome.
Representative Cervania.
Thank you, Chair. I'd like to ask the Senator a series of questions.
Go ahead.
Thank you. Thank you for presenting and clarifying what this bill has in its content. I do want to ask, can you clarify what specific problem this bill is trying to solve? Are there documented cases in North Carolina where a parent has been charged with abuse solely on the basis of gender identity care?
So,
Go ahead. You don't have to wait to recognize.
thank you. So I believe I started out with the specific problem that we want to address is the chilling effect on parents seeking mental health for their children if the child expresses gender dysphoria and has other issues, that a parent would not be reluctant to go to the doctor if they have anorexia, if they're suicidal, if there's something else going on, because they're afraid that the people at the hospital are going to call DSS and have the child removed from the home because they don't agree with the gender transition. That's a specific problem right there. As I pointed out, the Child Welfare Practice Guidance for LGBTQ+ youth in the state of North Carolina from the Department of Health and Human Services addresses some of these issues, saying child welfare workers should assess the parents' or caretakers' attitude towards the child's sexual orientation. I would say that absent abuse, harm, neglect, that I don't think the parents' attitudes toward about anything are relevant to whether or not they keep custody of their child. So yes, there are incidences around the country in the last couple of 3 years where parents have lost custody of their children. I do not know of one in North Carolina where a parent has had the child removed by the state. I don't think that we should wait for that to happen to a family. I think that that is too high a burden for a family to bear in having to hire a private attorney to try to get their own child back. Or there was a family, I believe it was in the District of Columbia, their child was taken when they were 16 and was placed in foster care for 2 years. I don't think any North Carolina families should have to bear that burden, and that's why we should go ahead and pass this bill and not wait for somebody to have that happen to them.
Follow up.
Go ahead.
So there's no specific case or complaints currently, even from DHHS or DSS counties at all, when it comes to even having the current law clarified. There's not been one case in our 11 million people.
I don't have total knowledge of everything that's happening with 11 million people. I have not heard of a case in North Carolina. As I said, I don't think we should wait for that to happen before we take action as a legislative body.
Follow up, one more question.
Last one, because we do have a couple public members who wish to speak.
Yes, sir. Thank you. So, in the creation of this bill, did you or your group consult with any pediatric mental health professionals or LGBTQ youth advocates, or even more specifically, major medical associations like the AAP, AMA, APA, when it came to developing this bill?
No, ma'am. I consulted with common sense and ordinary knowledge about what happens in families and how to help children in distress.
Thank you very much. We do have 4 speakers, and there's a Callie DeThomas, Joseph Blackholt, John Rustin, and Rayleigh Collins. We'll take them in that order, and we will have 1 minute. So, Callie DeThomas. And if I've mispronounced your name, I apologize.
Hi, thank you so much. My name's Khalil D. Thomas.
Sorry.
Democracy Out Loud. I do want to say that my friend here, Mark Swallow, was signed up on the list before I was. Do you want me to speak
Oh, I'm
first?
sorry. Go ahead.
Okay,
I'm sorry I missed
thank you. A friend of my daughter's, about 11 years ago, began transitioning. I had a conversation with her mom, and she told me that it made her uncomfortable. But she said that her child was suicidal, and she stopped feeling suicidal as she transitioned to a boy. She told me that her discomfort was not worth the life of her child, and now she has 2 healthy adult sons instead of 1 son and a deceased daughter. Recently, speaking with a trans friend of mine, he told me that when he transitioned, his parents stopped talking to him for years. That was hard on my friend, but his own well-being came first. Senate Bill 442 would literally put the comfort of caregivers preeminent above the lives of adolescents and teens. I urge any of you who are parents or who care for young children to vote no against this bill. Thank you.
Thank you. Okay. I'm sorry, Mr. Swallow, you're up next. I've missed you on the list.
Thank you, sir. My name is Mark Swallow with Democracy Out Loud. I volunteer at Oak City Cares. It's a center here in Raleigh that serves the homeless population in Wake County. There are a number of young people that are there that have been kicked out of their homes because they're LGBTQ+. So not all parents are perfect. And it is also a federal mandate that we're supposed to look at child's health, safety, which must be paramount, not the parents. So we need to make sure that we're focused on the children, not the parents. It's proven through numerous studies that social affirmation in childhood, names, pronouns, and clothing lead to normal levels of anxiety and depression compared to their peers. Puberty blockers are effective and reversible, and they significantly reduce psychological distress and suicidal thoughts in transgender adolescents. Long-term effects of early hormone therapy that start in mid-teens show strong improvements in mental health. And adolescents who receive timely care report better outcomes in adulthood, including lower suicide rates and better life satisfaction. And the regret rate, by the way, is 1% to 2%. That means that 98 to 99% of the people that go through this process are happy that they did. Thank you.
Thank you very much. Joseph Blackholm.
Thank you, Mr. Chair. Joseph Backholm with the NC Values Coalition in support of 442. This is a good and I think a reasonable bill. No one wants children to be abused. There is a well-worn standard the courts have used for a very long time to determine how abuse and neglect cases are evaluated and assessed, and a refusal to obey your teenager has never been one of the criteria that has determined that. This bill is an attempt to make sure that we are not redefining what abuse is. The foster care context was mentioned. That was in the bill that the House previously passed out. I do think it's important to continue to consider that case because there are several states, Representative Loftus mentioned earlier, who have affirmatively banned, disqualified any families who do not affirm the idea that a boy can become a girl from the foster care system. We think that's a big disservice, an issue that we hope we will continue to discuss moving forward. Thank you for your time.
All right. John Rustin.
Thank you, Mr. Chairman, members of the committee. I'm John Rustin, president of the North Carolina Family Policy Council. NC Family wholeheartedly supports Senate Bill 442. as this legislation seeks to protect the rights of parents to raise their children consistent with their God-given innate biological sex as either male or female. We've seen efforts, as you've heard about in other states like California and Colorado, to take children away from their parents if the parents refuse to act in a way that affirms a child's gender dysphoria or gender confusion. Senate Bill 442 would protect parents from being accused of abuse or neglect for raising their child in accordance with their biological sex. The bill would also apply a similar standard to adoptive parents. Parents should never fear reprisal from the government or others for recognizing and acknowledging the difference between male and female and raising their children accordingly. For these reasons, we urge you to support Senate Bill 442, the Parents Protection Act. Thank you.
Rayla Collins.
Riley Collins, go ahead.
ACLU of North Carolina. Senate Bill 442 is a bill in search of a problem. Parents in North Carolina are not being criminally charged or losing custody of their children because they refuse to support their child's gender identity. There are several commonly cited examples meant to highlight the need for these types of bills and given as so-called evidence that family courts in blue states are depriving non-affirming parents of their children, such as Mary and Jeremy Cox in Indiana and Adam Vina in California. But per court records, these cases are not actually based on the parent's refusal to accept gender transition and are instead centered around other forms of abuse and neglect in the home, such as domestic violence, failure to appropriately treat severe eating disorders, harassment, and violation of court orders. Rather than solving a problem that doesn't exist, this bill unnecessarily attacks trans children and their families and further marginalizes trans youth, an already incredibly vulnerable population. Parents and guardians should do everything they can to make all youth in their care, including LGBTQ youth, feel loved and accepted, and politicians should not be passing laws encouraging rejection of these youth. Thank you.
I think that's all of the people who signed up. Any further? Representative Bell.
Yes, thank you. Actually, I was going to ask a question about the case that the senator cited, but the last speaker eloquently spoke about that. I was going to ask if this person was diagnosed with a dysphoria and other conditions, and she just answered that it wasn't just that. But let's say that's the case. If the experts say this is the treatment that we recommend, and we recommend that they go through the process that they need to go through in order to have their bodies go with their identity. What you're suggesting by this is that if people are uncomfortable, who are the parents or who are the guardians, that we ignore what the experts, because I think you said it yourself that we aren't the experts, but what the experts say are best for that child, physically and mentally. Am I misunderstanding that?
Senator Gailey.
So I think the better analogy in North Carolina law is to when you have a parent who refuses to give consent to life-saving procedures like a blood transfusion. To my knowledge, if you have, I believe a Jehovah's Witness is a religion that does not agree with a blood transfusion. If you have a child who needs one and the parents won't consent, then there's a process for the hospital to go to a court to get an order from a judge, so that, and there's a burden of proof, and there is a hearing to be sure that that the parents' due process rights are protected while the child gets the treatment that the experts, as you say that they need. I don't believe that in those circumstances we talk about removing the child from the home because the parent doesn't agree with the blood transfusion. So it's quizzical. It's a puzzle to me why we have lived with that kind of statute for, I don't know, probably 30, 40, 50 years, and it's not been a problem. But suddenly when you have a child who expresses gender dysphoria, it becomes a problem. So I think that we should look at it in the same manner as parents who are struggling with their religious faith and life-saving treatment in other ways.
Follow up.
Yes, thank you, Mr. Chair. What you're citing is not the same thing, I don't think. I don't think you compare them. Unfortunately, I've dealt with people who have had severe injury in my family and had to be hospitalized. But I've also dealt with people who have mental illness. And you don't go in and get one infusion and say, okay, they're cured. Unfortunately, I wish that were the case. What you're dealing with here is dysphoria that deals with mental health and the well-being of who they are fundamentally and what they are. It's different from treating a person for a physical ailment, because this involves the psyche and who they are. So I think it's we're talking about two different things here.
Dr. Daly.
Well, I didn't say they're exactly the same, but they are analogous. You have a life-saving treatment offered to somebody with a blood transfusion. We've heard from speakers who claim that being able to transition genders is a life-saving treatment. In one case, the parent's ability to continue to parent is not brought into question, to my knowledge. In the other case, the advocates are saying that refusal to go along with the life-saving treatment is in itself a reason to remove the child from the home. I think that while they're not exactly the same, they're very, very closely parallel each other.
Representative Crawford, and then we're about done with time, and then we'll entertain a motion. But Representative Crawford.
Thank you, Mr. Chair. This isn't a question, just more of a comment. And, what I would say here is that a child who is going through gender dysphoria or something related or looking to transition, who is not supported, faces significant mental health concerns. And they can certainly get that support in a variety of ways, but if they do not have a parent that is supportive to make sure that they get them to the mental health professionals so that they can work through that whole process, as you heard from Representative Belk, this is a life or death situation. Children who are LGBTQ+ are much more likely to die by suicide than other populations. And so that's not a question, it's just a comment, and I think that this bill is incredibly flawed.
Okay. Any other comments, or all? Representative Cunningham, last comment.
Thank you, Mr. Chair. I'm sitting here and I'm hearing you're saying mental health, you're saying LGBTQ, we talk about suicide. Suicide ideation is not necessarily connected to whether you're LGBT. Those exist because of multiple additional sub issues that are going on. It's not just one issue that gets you there. So I hate that we try to connect things like that. We shouldn't connect it like that, because every child that is in a household that the parent is raising that may have different beliefs and different cultures that are raising that child and that's responsible for that child until they're 18 years old should not be the king in the house. Yes, we should be providing the best opportunity to get the care that they need, but that doesn't eliminate, once they get that care, they coming right back into that family, right back into that same culture that they're going to have to survive through.
Representative Loftus, I'll entertain a motion.
Thank you, Mr. Chairman. I have a motion for favorable report for Senate Bill 442 with a referral to rules.
Okay, the motion's before us. All in favor say aye. Aye. All opposed say no. The ayes, in the opinion of chairs, the ayes have it. The ayes do have it, and this meeting is adjourned.